refers to the way that an individual is affected by the conduct of another person or persons. Ethical considerations can be defined as an accumulation of values and principles that address questions of what is good or bad in human affairs. It searches for reasons for acting or refraining from acting, for approving or not approving conduct, for behaving or denying something about virtuous or vicious conduct or good or evil rules. Therefore, ethics refer to what is good or bad, what is right and fair, what ought to be done and what not. The practice of health or practice of medicine is very intimately concerned with a person's body, of personal vulnerabilities and well-being. Therefore, it is subject to legal and ethical considerations, all of which have evolved or been designed to protect patients' interests. They constrain healthcare practitioners to behave competently and ethically, and to conduct themselves with probity. Ethics is there to determine or to guide a person's decisions and a person's action. Both ethics and law are important. The law guides a person regarding to what is right or wrong legally. For example, the Pharmacy Act, the Medicines and Related Substances Act. But ethics is about what is moral. But what is moral and what is legal is not always the same thing. An action may be legal, but it's not ethical. For example, when an abortion is being performed, it is legal, but it may not be considered ethical by other healthcare professionals or members of the public. Ethics applies to everyone working or practicing in the sector of healthcare. The fourth principle with regard to ethics is the principle of autonomy. And this is a principle that I want to attend to in more detail. This literally means self-rule. Everyone has the right to make decisions for him or herself. In healthcare, this would entail allowing the patient to make the final decision regarding his or her treatment after providing all the necessary and relevant information. This principle should not be used for persons who are not autonomous as a result of them being immature, incapacitated, or ignorant, or being exploited. For example, children, suicidal individuals, psychiatric illnesses that would render them incompetent. Respect for autonomy creates the following obligations: informed consent, confidentiality, truth-telling, and effective communication. Patients must be given sufficient information in a way that they understand and in a language that they understand in order to enable them to make an informed decision with regard to their treatment, in other words, which is right. The National Health Act in Section 6 provides that patients must be given information about the health status of the patient, unless there is evidence that such disclosure will not be in the best interest of the patient. It is important to note that if you as a healthcare practitioner withhold any information regarding the health status of a patient, you must record the reason for that. The patient must also be given information with regard to treatment options and diagnostic procedures being available, information about the benefits, the risks, and the costs of each option, information with regard to the right to refuse and the implications of such refusal, and the right to a second opinion. If a patient insists that he or she does not want to know about his or her condition in full details, you should still provide the basic information. This now brings us to the question of whether we may treat patients without their consent. The National Health Act in Section 7 makes the following provisions. A patient could mandate someone in writing when he or she is still competent to act or consent on his or her own behalf. If this was not done, a person authorized by a court, for example, a curator, can do so. Also, if no mandate was given, consent may be given in the priority order of a spouse, then a partner, a parent, a grandparent, a major child, or a brother or a sister. Consent can also be given in terms of a law or a court order. It can also be given if failure to treat will result a risk to public health, or if delay in the provision of the health service might result in the death of the patient or irreversible damage to his or her health, and the patient has not refused such treatment, then such treatment must be provided. With regard to consent of children to medical treatment or a surgical procedure, a child of the age of 12 years can give consent to medical treatment if that child is mature enough and has the mental capacity to understand the nature, the purpose, and possible consequences of the proposed treatment, also of non-treatment. If a child is under the age of 12 years and does not have sufficient maturity or the mental capacity, the parent, the guardian, or the caregiver can give consent to medical treatment or a surgical procedure. A child of the age of 12 years can give consent to a surgical procedure if that child is mature enough and has the mental capacity to understand the nature, the purpose, and the possible consequences of the procedure, and that child is assisted by a parent or a guardian. If it is necessary to preserve life or prevent lasting injury or disability, and consent cannot be obtained through the required manner, the superintendent of a hospital can consent. If a parent or a guardian unnecessarily refuses treatment or a procedure or cannot be traced or is deceased, then the Minister of Health can give consent to a medical treatment or surgical procedure. This can also be done if a child unnecessarily refuses the medical treatment or surgical procedure. It is important to note that a female child of any age who is legally competent to consent to termination of pregnancy and has the mental capacity, that child can give consent if that child also understands the risk and the benefits thereof. This slide contains a summary of consent provisions with regard to medical treatment, surgical procedures, HIV testing, contraceptives, and virginity testing and circumcision. It's just for you to look at and have. Healthcare workers explicitly or implicitly promise their patients that they will keep information provided to them by the patient confidential. If the patient does not have this assurance, they are unlikely to divulge highly private and sensitive information that is needed for optimal care. The National Health Act in Section 14 gives exceptions to this. When a patient consents to disclosure to another party in writing, or when there's a court order or a law to make that information available, or when there is a threat to public health if there is no disclosure. The National Health Act provides that when consent is being obtained, that consent must be in a written form. The Act also states that the visit of a patient to a healthcare professional and the health condition of a patient, as well as the stay of a patient in a hospital or another institution, is confidential and should not be shared with any other person without the expressed consent of that patient. Sharing of the information of a patient between health professionals is allowable only if it is in the interest of the patient and is necessary.